start off then with Modern Wealth Management versus R. Drew Jones. So Ms. Dwyer, are you going to be the only one of the two of you actually arguing? Okay, you can go ahead and step forward and get started.
You may need to give me a warning, Your Honor, when I get close to my 12 minutes.
I will certainly
if you
do
can.
that, if I remember to do that. Okay.
Thank you. May it please the court, counsel. We are here today to ask this court to vacate the lower court's mandatory injunction, also known as the neutral notice order in our briefing, that ordered Modern Wealth to send a notice to its customers advising that its former advisor, Drew Jones, had moved to a new employer and to provide that new employer's information and contact information to those customers. The court entered the order sua sponte without any predicate legal wrong to support the injunction, without any request having been made by pleading or by motion.
And you, just to clarify, you're just saying that one part of it was sua sponte.
Exactly. So in terms of what we are appealing today, there is one journal entry of judgment, but there's two orders within it. The first paragraph was the injunction against Mr. Jones, prohibiting him from sending the same type of notice to these customers. The part we are appealing is paragraph 2, which orders Modern Wealth to send that type of notice.
And before we go, you used the term sua sponte, perhaps it was, maybe it wasn't. It's always a good use of Latin whenever we can. But isn't a preliminary injunction an equitable remedy?
It is an equitable remedy.
So you were appealing, not in the sense of appealing here, but appealing to the district court judge for equity. Do what is fair, do what is right. It seems like they can shape an order however they want once you appeal to their equity.
Sure. This is the argument that comes up a lot in the briefing, particularly on the defendant's side. An injunction is an equitable remedy. It's an extraordinary remedy. But the law provides that one has to have a remedy. An injunction can't exist in a vacuum. You have to have a predicate legal wrong that the injunction, the remedy, is supposed to right. And that is a fundamental problem here. Equity can only go so far. Equity runs up to the bounds of what a statute provides or what the Constitution provides or what the procedure is. And here, without this predicate legal wrong to be righted, that was pleaded and that was requested, equity cannot solve this. Because the order essentially asked Modern Wealth to do what Jones could not, it would end up and result in the irreparable harm being caused that Modern...
I don't understand. You wanted to stop Jones from sending a letter to his 100 and some clients saying, I've moved. And all the order says your company is to send a notice saying that he has left their employment.
That is not the actual extent of the full order. The order has 6 components to it. One is to send and notify people that he has left, to notify the new advisor, to advise that the court has ordered the notice and to include the order, but also to say that Jones is now employed with Dogwood, who is the competitor, and the contact information that where he may be reached. And if you look at that compared to the tombstone notice, which is Exhibit H to the verified petition, that is essentially the same thing that he was enjoined from sending out. We attached that to the petition to show what type of solicitation was going on in violation of his restrictive covenants. And so we filed the motion, we sought the relief, we cited that solicitation, we went in, brought in evidence, made argument, and the judge said, yes, I agree, Mr. Jones, and he looked at him, and I think it directly addressed him, said, you're not going to send those anymore. But then immediately turned to Modern Wealth and said, but you're going to send it. If I were to give a very simplistic example to compare this to, if I have a tree on my property line and my neighbor wants to cut it down and I don't want him to, I can go to court and ask the court, please enjoin him from doing that until we can resolve this property line dispute. And the judge can look at him and say, that's right, don't cut it down until we resolve this. But he shouldn't turn to me and then say, but you cut it down. And that's the real crux of the problem here in terms of the irreparable harm. But initially, we think this is an abuse of discretion for essentially 4 reasons. First, that there is no predicate wrong. The law of Kansas requires that a remedy has to remedy some wrong, and that under Kansas has to be a legal wrong set forth as a cause of action. It cannot be unsupported by a cause of action of this legal wrong. And here, there was no counterclaim made at the time. There had been no motion filed at the time. So without that legal wrong to be righted, this injunction simply cannot stand, and that is fatal. The second issue is this notion of there was no motion that was filed or request made. Modern Wealth never sought this. No party ever sought this. Without that, there can be no notice then or meaningful opportunity to be heard. Modern Wealth gave notice by filing it in its verified petition and seeking the relief, by filing a motion, laying out all the factors. There was a hearing that was set a month and a half after the motion was filed, 2 days of evidence at which both parties got to put on evidence. And at that time, there was no reasonable notice that Mr. Jones or Dogwood was asking for this type of relief to be a mandatory, by the way, for Modern Wealth to have to comply with. And for it to be a meaningful opportunity to be heard, we need to know in time so we can brief it, call witnesses, argue it, and we just simply did not have that by the time the judge made his order at the end of the hearing.
Point to me where in the record you challenged the district court's authority to grant this. I know you moved to modify it, and it looks like you're really just complaining about 2 of the provisions of the 6, but where in the record did you raise the argument that the district court lacked the authority to order the neutral, what I'm calling a neutral notice? I don't know if that's the correct term.
Sure. The record is probably not the best in terms of kind of consolidating and most efficiently bringing the issue to the court's attention. It wasn't brought up at the hearing because it came at the very end of the hearing, and there was no real time to do that. We immediately started working on the journal entry and filing it and put in that journal entry in the initial draft, which I think is in the record, that we plan to appeal. There is the right to appeal immediately, meaning before the end of the case. And so the arguments really come up, I think, very crystallized in the motion to suspend or stay pending the notice of appeal. And so in that, we talked a lot about the substantial likelihood of success on appeal. And so you'll see in that briefing that we do discuss the discretion of the court. We discuss that the factors weren't met. We discuss that there's no predicate wrong. We discuss that there was no motion filed. So it may not be the perfect way to have brought it to the court's attention, but he did have it in front of him and he denied that motion. And I know the other side has argued at times that we did not bring up abuse of discretion. Really, I don't argue to my district judge, you've abused your discretion. I argue that to this panel.
But I often objected until I became a district court judge. Then I loved everything they did. But
Yeah.
but when I was in your shoes, I would at least object to their journal entries. I just wanted to ask you about the posture of this case. You know, the other side has accused you of being, since KU won last night, we'll call it the 4 corners offense, that you're primarily trying to run out the clock here. Whether you are or not, that's up to you. But I do see that Mr. Jones left the firm in 2024. So as a practical matter, what relief can we give you, and are we only talking about a month or so?
Not a month, I think about 8 months or 9 months. His non-solicitation agreement lasts 2 years after he left, and he left in October.
And you would agree 2 years is reasonable because that's what the statutes now say.
Yes.
Okay.
Yes. Yeah, we have no
So
problem.
when did he leave?
He left October 4, 2024. And
So October 4, end of the day, October 4, 2026.
actually early in the morning, he walked in, handed in his resignation, and then immediately drove to the post office to mail his notices.
So this whole thing goes away, at least from an injunction part, in October.
I think that's fair.
And you're also in arbitration?
Yes. So we have, perhaps the court is familiar, often, sometimes these employment agreements will say, we agree that we're going to go arbitrate any disputes about this agreement. However, in this case, Modern Wealth, because of the issues related to the restrictive covenants, the parties agree that Modern Wealth can go to the court to get injunctive relief to maintain the status quo until the matter is resolved in arbitration. So I believe, Your Honor, you asked me what relief could you give? And I think, we arguably, this probably should have been here months ago before the court. And you can see from the record why it didn't get here. I still think that the resolution is to vacate the order. I think that's the only real resolution under the posture of how the order came about without any predicate legal wrong being the issue. It really can't remand it because there hadn't been a motion or a proceeding specific request. So I think we just simply ask that the court vacate the order for the abuse of discretion.
Thank you.
I also want to note that,
You have about a minute.
thank you. I do want to note that 5 factors that are required for temporary injunctive relief just aren't shown anywhere. And this is a mandatory injunction ordering an affirmative act that changes the status quo and could cause irreparable harm. That requires heightened scrutiny by the district court. And in fact, this court said in the Hildenbrand case, you have to have scrutiny to show a compelling right to relief, and a clear right has to be at issue. And with that, Your Honors, I would ask that the court vacate the order. Thank you.
Thank you, Mr. Hare. Mr. Jones, are you going to make the argument? Or I'm sorry, Mr. Hare. Jones on the mind.
Hope it's not the suit or something. May it please the court, counsel. I realize I have limited time, and so I want to get straight to some of the issues I could. I want to clear one thing up very quickly and move on. As it relates to arbitrability, she is right. It went to arbitration. The Judge Harper, said, I'm going to send it to the arbitrator so he could determine what is arbitrable or not. What he said specifically is, when it comes back, or if it comes back here, I want to know what I'm trying, so I'm doing this again. I understood that. The arbitrator decision, and he said that anything dealing with confidentiality is off the table for arbitration. So we're going back to the district court. I just wanted to clear that up quickly. Moving on to some of the issues I'd like to cover. One thing that hasn't been covered and that I think is important is the issue of jurisdiction. Our position is that this court doesn't have jurisdiction to even look at this matter. And the reason being is because they didn't file in time. As you know, 62102, you must file within 30 days. They didn't file within 30 days. They filed within 55 days or 53 days. I'm sorry.
But I thought there was a premature notice of appeal.
The premature notice of appeal, I don't believe is appropriate in this standpoint. That statute, as I understand the statute, and as we read it, deals with those judgments that are final. This is not a final judgment. This is a temporary injunction. And so we're back to the 30 to the 30 days. Now, the court, the Supreme Court, as well as the appellate court, has looked at this issue, has looked at the issue in Linden State Bank. We cited that where they said that a journal entry is solely for the court's convenience. We cited Brown versus Brown. A journal entry is not an order, it's a judgment. It's not effective until the journal entry is prepared and filed. Judge Harper, when the argument was put before him, said it succinctly, and I quote, "Does anybody really think that when a court orders something, it doesn't count until it's journalized?" Which is sort of the point. And so the notion that you can simply wait until there's a journal entry for the court to have any legs would turn Kansas law on its heel. In fact, it doesn't make much sense. This court, and I have to apologize, it's a case that we just found. And I understand, because part of our argument, as I'll get to, as I'm sure you've read the briefs, is that they did not argue abuse of discretion. They hinted at it, and hinting doesn't cut it in any state I've ever practiced in. But I'm going to draw the attention to the court on one case. I'm not changing an argument. We just found a case. The case is in the matter of care and treatment of Christopher Straith, S-T-R-A-I-T-H. I assume it's Straith. I apologize. It's 79 P3rd 795. I just very briefly want to go through this. On April 17, 2000, trial court granted a continuance during a teleconference. The written journal wasn't completed or signed until May 4th, 2000. Just as we have here, the defendant there argued that the judge's order was not effective until a journal entry went in. This court disagreed. They found that because the continuance was granted on April 17, the date of the teleconference, that's the relevant date, not when the journal entry came in. That is on forwards exactly what we have here. If you take their argument, which is the basis of why we're here, it's simply that the judge made an order on a certain date. We get to ignore that until there's a journal entry. There's no support for that. It simply makes no sense. But that is the backbone of their argument. Modern Wealth's actions are inconsistent with their argument in this way. According to them, nothing's effective until it's signed, the 170. The problem with that is, in this case, the 170 was signed July 10th, 2025. So if you take their argument and take it to its logical conclusion, not illogical, logical conclusion, Mr. Jones could have simply continued to send out anything he wanted until the 170. Well, he didn't, because the judge, as she just said, you have to stop that right now. And we did, because when a court speaks, you do what the court says. That is irrefutable. That's in the record, and I'm glad that she brought that up. To prove this further, if they believed what their pleadings say, then why did they, on July 24, 2025, file a motion to stay in the stay? Also, on January 2025, the district court's order was effective immediately. That's what they argued in a hearing. So they knew it was effective the minute Judge Halber, this is what he's going to do. I think we're conflating compliance with appealability. And that's a real issue here.
So why did it take so long to get the journal entry filed?
I wish that courts were a place where you knew the judge well and you could make a joke and it went over well. But I don't know you and I can't make that joke. And I don't want to use up much of my time. But I will suffice to say both parties would take the following position. We drug our feet, they drug their feet. I mean, if we're boiling it down, the judge was not comfortable with either side that it didn't go sooner. And in fact, at a hearing, what he said that, and you'll see it on 170 journal entry, he said, listen, my order was way back then. We are not going to put a journal entry out that suggests that the order is effective just now. It's not. It's effective when he had it, when he made his on the bench. That's the long and short of it.
Thank you.
Regarding the issue of abuse of discretion, I want to drill down on that just a little bit. In the state of Kansas, you don't, as I understand it, I've got 32 years of doing this with Kansas. In the state of Kansas, I've never heard of the ability to simply say, you know, I didn't say it, but I mean it. When a standard, you have an obligation, as was mentioned by you all earlier, to say what you're arguing. They did not. In the case, I'm sorry, Your Honor.
Isn't it kind of a nonsensical in a way? I mean, they're asking the court to reconsider their decision. They're saying, I think your decision was right. So you're saying they need to use those magic words. I mean, their request was that, right? I mean,
No, the request was that he didn't have authority.
Mhm.
And that could be a distinction with a difference. In fact, when I brought this up at the oral argument, here's their response. I said, Your Honor, they're now wanting to argue about abuse of discretion. They've never argued about that before. Here's the quote. The abuse of discretion standard. While we may not have said that phrase in our brief, that falls into substantial likelihood of success. Well, maybe it doesn't, maybe it doesn't, but we have rules for a reason. And to hint at it is not enough. This is the first time it's been brought up. It's on appeal, and Kansas law is very clear about that. To the crux of the matter, we've heard my opponent consistently talk about a mandatory injunction. I want to disabuse the court of that notion right now. This is not a mandatory injunction. As Judge Halber said, in as many cases that we've cited, you come into a court of equity, you get equity. You don't get to come back and say, I just don't like what you did, Judge. That's what's happening here. You asked for equity. You asked the court to use their broad powers of equity, and that's what happened. So the notion that we have a mandatory injunction is predicated on one thing. It's predicated on the belief that the judge found against Modern Wealth. Nothing could be further from the truth. You guys have the record. I know you've looked at it. The judge went out of his way many times, every time they brought up this argument, to say the following. I didn't rule against you. You came in for equity. You got equity. Now, as it relates to Modern Wealth, in terms of what was ruled against them, they came in for a temporary injunction. They got a temporary injunction.
What about this argument, because we're about out of time, that there was never a request to require them to send out any kind of letter, that this kind of came out of the blue, never requested, but are you saying equity allows the court to do something that was not requested, that was not part of the pleading?
Yes, in certain cases, but that's not the case here. Okay, we're looking at this not we, I would suggest that perhaps you could look as in a vacuum and come to that conclusion. But the reality is this: the judge is required to look at all of the underlying evidence and to craft a remedy. The evidence at the 2-day hearing was this: 30 affidavits, 30 declarations from people that said Drew Jones never solicited them. Drew Jones didn't reach out to them. I was not pressured. We brought 10 witnesses in. They said the same thing. And here's what's important to think about in terms of the context. They said, did you ask where Drew Jones went? You know what the answer was? They didn't tell me. And they testified, and it is beyond contradiction that they lied. We'll have Mr. Jones call you right back. Mr. Jones was gone. He left at 8:10. And so at 8:10,
So you believe it was that evidence that compelled the court then to require wealth management to send a letter?
well, it's that in the totality. I mean, I'm running out of time, but that just gives you a small sense of that. Here's the other thing. When we talk about that, we're forgetting about the testimony of the CEO of the company, and we're forgetting about the legal compliance officer who testified to the following: it is not a violation of the contract, which is the core of this, to reach out to someone, to take business that's offered to you, to initiate contact, to take phone calls, to answer questions if people ask them. That is the architect of the employment agreement saying this. And so when you take that all in context with the other things, my argument is it's an abuse of discretion if he didn't do it. The judge has been very clear on his cases for the last 15 years, maybe 20 years. There's a strong public policy that people need to know where their financial advisor went. And to quote him, because I have gray in the beard, I can do this. He said, silver-haired people like me need to know. You've worked all your life and someone leaves. People shouldn't be lying to you. They ought to tell you where they are. That's what this case is about. They just don't want to tell where he is. And that's not right.
Your time is up.
Thank you.
No, thank you.
Any other questions? Okay, thank you very much, Mr. Harris. Squire, you have 3 minutes.
I'm not quite sure where to begin. I'll start with the fact that just to point out that where the case is currently is not before the court. It's not in the record. So the arbitrator's decision and all that. And I will note that we disagree with how Mr. Harris has characterized that ruling. So I don't know that the case will be back. So I just want to make sure that's clear for the record. I will only point out that Modern Wealth would strongly dispute that there was quote unquote lying in the record. The transcript, you have it, it's clear. You can read it and see if what Mr. Harris has represented is accurate. In terms of the policy, if we view this as a mandatory injunction, which we do, then we had to look at the public interest. And it is not that this is not a valid public interest to be considered. It is. But if understanding there's no movement here, but if Mr. Jones had an obligation to prove the 5 factors that are required for injunctive relief, that is only one of them. There are 4 other factors that have to be proven. Public policy, that public policy or public interest in this case is simply too thin of a reed to support a mandatory injunction when it wasn't requested. There was no legal predicate, no wrong to be righted. And there are other public interests at stake: enforceability of contracts, enforceability of restrictive covenants, which has been strengthened now with the amendment to 50-163. Legitimate business interests in Kansas include customer relationships, and we've known that for a very long time. Weber versus Tillman is very clear. So it only can go so far in the context of the judge ordering Mr. Jones, don't send these notices to going to Modern Wealth and say you do. I'm not going to address the motion to alter or amend. I think we'll just stand on our briefs. And if the court doesn't have any questions, we would simply ask that the court vacate this notice. The paragraph 2, we want to be clear about this. We're only appealing paragraph 2 of the journal entry, which is the neutral notice order, that it be vacated for an abuse of discretion. Thank you, Your Honors.
Questions? Thank you very much.
Thank you.
Thank you to the parties to this case. We appreciate your argument. The argument and briefing in this case, I have to say, has been superb. Dragging of feet, maybe, but at least you've got some superb arguments out there. So thank you very much. We'll take the matter under advisement and issue a decision as quickly as possible.